debate over House redistricting certainly now is before the New Hampshire Supreme Court, and last week we had written briefs that were submitted to the court by all parties, making the case that from the 5 lawsuits that have been filed, that this House redistricting law is unconstitutional, primarily because it violates the 2006 amendment to the state constitution, which essentially said if communities or city wards have enough population to get their own legislator, then they should get them. Now, the House redistricting law, as we pointed out, leaves about 60 of those city wards and towns without their own legislator. Now, the legal argument that the House leadership has been making throughout this has essentially been that, look, we support the constitutional amendment, but the federal one-man, one-vote principle overrides that, trumps that, and is paramount. And that's what we used primarily in drafting this proposal. So last week the Supreme Court essentially decided we're not going to suspend the candidate filing period while we hear these lawsuits. And we're going to have the oral arguments on these lawsuits on June 6th, which also happens to be the first day of the filing period. So Secretary of State Bill Gardner will go forward with the House redistricting law as it now stands. And candidates will file under those new districts, and they are significantly different. And once the Supreme Court makes a decision, if they were to overturn this law, then the court would have to order a different filing period, a second filing period. But the court has a number of different options. They can sustain the House redistricting law, essentially say that's the legislator's job. You haven't proven that the law is unconstitutional, so we're not going to deal with it. They can say to the House that we find there to be constitutional flaws with this, and we're sending it back to you to try and fix them. They can do what the 5 lawsuits ask them to do, which is rule the law unconstitutional and leave it at that, which eventually could certainly get the Supreme Court in the same sticky mess they were in 10 years ago when the Supreme Court wrote the districts for the State House and the State Senate. And the court certainly found that a very uncomfortable predicament to be in, and that led to 3 filing periods in 2002. There was a filing period for all other officers, there was a separate filing period for State Senate candidates, and there was a filing period for the State House candidates. So I think the court wants to avoid that if they can. I think, frankly, the court took a long time to recover its relationship with the legislature as a result of that whole mess, particularly with the Republican leaders in the legislature. So, but they'll rule on the constitutionality of the law, and certainly there are serious arguments to be made in those lawsuits. So some folks, I think, jump the gun when they say, well, they wouldn't suspend the filing period, therefore they're going to uphold the law. That's not necessarily the case, and I've seen before in cases such as this that just because you don't get an injunction doesn't mean you don't win the lawsuit. But stay tuned, we will too.